evidence and hearing. And today's topic will be the refugee hearing, which will be presented by our barrister, Barrister David Ibeawuchi. Again, Barrister David Ibeawuchi is of the Fusion Law, from the Fusion Law. It's a Toronto-based Canadian immigration and litigation law firm dedicated to providing expert legal representation in immigration, refugee, and litigation matters. Their experienced team of lawyers offers personalized guidance through complex legal processes, including applications, appeals, litigation, and judicial reviews. Fusion Law's mission is to provide clients with strategic solutions tailored to their unique needs, just like what has been helping some of our participants or clients, the NELO Immigrant and Community Services clients, ensuring exceptional service and the best possible outcomes. Fusion specializes in assessing eligibility for various immigration pathways, helping individuals and families successfully navigate Canada's immigration system. So in collaboration with NELO Immigrant and Community Services, which is NICS, Fusion Law also offers educational workshops designed to inform and empower our communities. In other words, we are partnering with them, we are collaborating with Fusion Law in as much as this particular program is concerned, that is being funded by the Law Foundation of Ontario. So welcome everyone for attending this workshop. We will start because the topic is broad, so we'll be able to cover, the outline of the program. We're almost 25 minutes to the time. So thank you so much for attending while others join us. Welcome, Barrister David Ibeawuchi. The floor is yours.
Thank you very much, Dr. Dorothy. Good evening, everyone, and welcome. My name is David Ibeawuchi. I'm a barrister and solicitor at Fusion Law Professional Corporation, and I'm very pleased to be here again with NELO Immigrant and Community Services to deliver this workshop titled The Refugee Hearing. So thank you all for taking the time to be here. I know many of you are preparing for your refugee hearings and supporting family members, or simply learning how you can better understand the process. So whatever brings you here today, you're in the right place. Today's session is focused entirely on the refugee hearing itself. So the key stage of the process where you tell your story and where the Refugee Protection Division decides your claim. So this workshop builds on our first session where we covered eligibility, making a claim, the BOC, the basis of claim, and early preparation. So today we go deeper. We will look at how the hearing works, who is involved, how your credibility is assessed, how to prepare yourself, and what happens after the hearing. And important legal protections like the Chairperson's guidelines. So before we begin, a quick few notes. This is purely an educational workshop. I cannot give personal legal advice during the session, but we can connect after if you need help with your case. So feel free to take notes. There will be time for questions in between the sessions. But if something is unclear, you may raise your hand and we can answer you. So this is a safe and respectful space. Some topics we'll talk about may involve trauma, gender-based violence, or issues related to sexual orientation. So you're encouraged to take care of yourself during the session. Okay, so let's begin. Understanding the refugee hearing, the Refugee Protection Division, I'll be saying RPD. So whenever I say RPD, I mention RPD, I'm talking about the Refugee Protection Division. So that's the tribunal in Canada that is responsible for hearing refugee claims. So the RPD hearing is where your claim succeeds or where your claim fails. Many claimants underestimate this stage. They think the paperwork carries the case, but in reality, your spoken testimony is the most important evidence on that day. So the Immigration and Refugee Board is an independent and a quasi-judicial tribunal in Canada. So the hearing is also an independent and a quasi-judicial hearing, meaning that it is not a court, but whatever decisions are made there is legally binding. The decision maker must be fair, it must be impartial, and it must be a reasoned decision maker. And the member, who is also called the decision maker, must base their decision solely on evidence and the law. There is no emotion, there is no sentiment. So in refugee law, the burden of proving your case is on the claimant, but the standard of proof is low. So when I say low, it means it's on a balance of probabilities. In criminal trials and in regular judicial proceedings, the burden of proof is beyond reasonable doubt. But in refugee protection, the standard is low. The standard is a serious possibility or a reasonable chance. So you must show that you have a serious possibility or a reasonable chance of persecution, not certainty, not probability, but a reasonable chance of persecution if you return to your home country. This is important because a claimant does not need perfect documents. You don't need to have a perfect memory. And as a claimant, you don't need to prove every detail. The hearing is just meant to give the benefit of doubt where the testimony is credible. So the decision maker on the day of the hearing is called a member, is a member of the Refugee Protection Division. So the RPD member's job is to determine, are you telling the truth? Does your story align with the country conditions? And is there a real forward-looking risk of harm if you return to your home country? So this is why credibility is crucial, more important than the documents at that point. So understanding the structure of the hearing will reduce fear and help you stay centered. So at the opening of the hearing, the member will confirm your identity. The member will review the documents in the file, the consolidated list of documents with your counsel if you have one. The member will also ensure that the interpretation is working and is correct. You have an interpreter who understands you and you also understand the interpreter. The member will also explain the hearing process, and the member may ask if you have reviewed your basis of claim, your BOC recently, and if you understand the interpreter, and if you have any concerns and your general well-being for that day, if you're able to proceed with the hearing on that day. So your answer will set the tone for the hearing. So after that, there will be an oath and affirmation. At that point, this will be a declaration by you to confirm that everything you say will be the truth. So it's important to know that lying under oath can destroy your claim. If you forget something, you say so. If you don't understand something, you ask for clarification. So the next stage will be the stage of testimony and the members' questions. So this is the longest and the most important part of the hearing. At this stage, the member will ask you questions concerning your background, the details of persecution that you're going to face if you return to your home country. The member will also ask you the timeline of events that happened that made your life to be in danger, and why you cannot seek protection from your country. The member will also try to find out why you cannot relocate internally within your country and why you are afraid to return to your country. The member can also probe missing documents, delayed disclosure, where you fail to submit documents within the 10 days timeline before the hearing. The member might also probe contradictions and events that are implausible or unclear events in your story. So it's important to note that it's not about hostility. It's the role of the member to ask those questions to find out those facts that will help you succeed. And in order for your claim to be accepted, you must prove to the member that you're credible. Then there will be cross-examination if there is a minister's counsel attending the hearing. So usually a minister's counsel may attend the hearing if your identity is questioned, or if there are credibility concerns that exist, or if there are exclusion issues, maybe for serious criminality, or you have a status in another country. So the job of the minister's counsel is to ask the refugee board to refuse your case and make a finding that you are not a conventional refugee or a person in need of protection. So when the minister intervenes in a case, they usually send a disclosure. And when they send the disclosure will contain the grounds for the intervention. When they mention the grounds for intervention, they will also provide evidence. The evidence from the minister can include open internet search or evidence from your own documents that will be used against you in the case. So their job, like I said, is to test your evidence and to ask the refugee board to refuse your case because of some of the concerns they have, maybe identity or credibility concerns. So it's also your lawyer's duty to protect you from improper questions. And then the final stage will be the re-examination. So at that point, your lawyer can clarify any contradictions or correct any misunderstandings and provide rehabilitative testimony. Will give you the opportunity to speak on the areas that will best prove your case and show the degree of harm that you will face if you return to your home country. After that, the member might ask the lawyer to make legal submissions. So by making legal submissions, your lawyer ties everything together, your credibility. Your lawyer will make submissions based on your credibility, based on the supporting documents and evidence, based on the country conditions, and whether you meet the criteria for refugee protection as per Section 96 and Section 97 of the Immigration and Refugee Protection Act. The lawyer also makes submissions based on guideline considerations that the member should take note of. For example, Chairperson's Guideline 9, if the claim is based on sexual orientation and gender identity, or Chairperson's Guideline 4. So there are different guidelines. So the lawyer will tie everything together and make a submission to urge the member to grant you your refugee protection. So that's your legal argument. And then at the end of the hearing, the member might decide to give a bench decision. So when they give a bench decision, most decisions will be delivered orally on the spot. And if the claimant is accepted, the claimant will be conferred refugee protection at that point. Sometimes the member might want to communicate the decision in writing. So if it is oral, you will know immediately if you have won the case. So I'll talk about these participants that I just listed and their various roles. I'll explain deeply. So like I said, the RPD member is the most important person in the room. He's the decision maker who is going to make a decision on the case. So this member must be impartial. This member cannot rely on stereotypes, and this member must justify credibility findings and must consider trauma, cultural differences, and vulnerability. So members use structured decision making. So meaning that they evaluate your testimony piece by piece, and they compare it to your documents, and they compare it to your country evidence. So as a claimant, your role is to tell the truth, answer questions directly, and then avoid speculating, correct interpretation errors, where an interpreter uh, translates something into English that is not exactly the way you said it in your local dialects, and you find that there is a mistake in the interpretation. It's your role to correct that interpretation. You can also stay calm and don't argue with the member. You don't have to argue with the decision maker. You just explain whatever question that they ask you. And then it's important to know that your testimony carries more weight than any documents in the evidence, because your credibility will be tested through your oral testimony. Then the claimant counsel, the lawyer, the role of the lawyer will be to prepare you before the case, to guide you through the steps in the proceedings and protect you. The only role the lawyer has in the case is to advance your case and uh, protect you. The lawyer objects to improper questioning, and the lawyer makes legal submissions and ensures that the Refugee Protection Division member observes procedural fairness and the refugee law jurisprudence, the case laws, what the federal courts has decided in numerous cases. So it's the job of the lawyer to guide the board member to what the law is saying on a particular issue, wherever the member wants to use that issue as a determinative issue in the hearing. So without counsel, claimants often fall into avoidable traps. So it's important to have a counsel at the hearing. And then the minister's counsel, like I said, he's not always present in every case, but when he's present in the case, they challenge your identity, they challenge your documents, they highlight the various contradictions in your case, they test the plausibility of your story, and they raise exclusion arguments, asking the Refugee Protection Division to exclude you from refugee protection. So their presence is always strategic and is not automatic in every case. Then the interpreter is a neutral party. Interpretation issues are one of the leading causes of credibility problems. So it's your duty to speak slowly, pause frequently when the interpreter is interpreting what you say, and then correct errors immediately you notice them. If the interpreter mistranslates repeatedly, you have to tell the member at that point. If you have a witness, your witness should be relevant to the proceeding and should be relevant to the issues for determination in your case before you bring someone as a witness. Witnesses must be necessary parties if they have relevant evidence to provide in the case. Too many witnesses can complicate your case. So, how is your credibility assessed? The RPD uses like a multi-factor credibility framework, and you must understand each factor because they determine your outcome and what happens at the end of the proceedings. So I'll talk about internal consistency. So your story, your narrative must be consistent within itself. The member will examine the timeline, the sequence of events that you narrated in your story, the various dates, the names of people, the names of places, and then the locations that you mentioned. So, for example, if your basis of claim says you are attacked on the way from church, but during the oral testimony, you say, oh, you were attacked during the political rally, this must be explained. Not every inconsistency is fatal, but unexplained or implausible inconsistencies that go to the root of the matter can damage your credibility during the hearing. Then external consistency. So external consistency would be your testimony must match your basis of claim narrative. Your basis of claim is the foundation in your case. Your testimony must match your supporting documents. Your testimony must also match the country condition evidence, and your testimony must match port of entry notes. For example, you made a claim at the port of entry when you came into the country. Your testimony must match the notes that were captured by the immigration officer at the time you made your claim. So if your basis of claim says you are threatened by the police, but you testify it was gang members, this difference must be explained carefully in order not to impact on your credibility. And then the member expects natural detail in your case. So it's not a rehearsed detail. You must provide natural detail and not memorized detail, not also exaggerated detail. So on the other hand, the member also checks the plausibility of your story. So plausibility asks questions like, does the story make sense in the real world? Does the story make sense based on the country conditions? For example, if someone claims to have escaped a highly armed group by simply walking away, a member may find it implausible unless proper context is given. So plausibility is also one of the areas the member assesses when they are testing your credibility. And then trauma is very important because a lot of people who make refugee claims in Canada, they have experienced trauma, and the trauma affects your memory. Trauma can affect the way you narrate the sequence of events and your emotion, your disclosure, the documents you provided at the hearing, and then also your ability to speak and deliver a coherent testimony. Trauma might impact on that. So this is why the Chairperson's Guideline 4 and the Chairperson's Guideline 9 are critical. So claimants are not expected to present perfect timelines after domestic violence, sexual assault, imprisonment, or LGBT-related persecution. The members must consider the impact of trauma on your testimony actively and not passively. Demeanour. So this is the least reliable factor. A claimant may appear to be nervous, robotic, emotional, or passive. None of these factors mean that the claimant is lying, but cultural norms might affect your demeanor. Trauma might also affect your demeanor, and then mental health can also affect your demeanor. So demeanor should never be the basis for a negative credibility finding that will lead to a negative decision. Then corroboration. Your documents are helpful, but they are not required in every instance. The RPD knows that, for example, LGBTQ claimants, they may have no documents to prove certain aspects of their narration. In the same vein, survivors of gender-based violence, they rarely have police reports because you find out that most of the countries where they are running from, the persecutors are indeed the state agents and the police. So in such cases, corroborative documents are not required because the IRB already knows the country conditions and the situations that happen based on your personal narrative as it relates to your home country. Then, for like I said, victims of state actors, you're a victim of state persecution. You're not expected to get official records of your persecution from your assailants, the people who are persecuting you. In some cases, some witnesses, individuals who witness a particular event, they may refuse to write letters due to fear. They don't know what is going to happen if they write this letter, and they may refuse. And in that case, you don't have that evidence to prove that particular fact in your case. You don't have to be scared about that because the IRB knows that corroboration is not required in every case, although it is helpful, but it's not required in every case. So you are judged based on your testimony first, your documents, and then the country conditions. So there are some common hearing pitfalls that must be avoided. For example, forgetting your basis of claim. So claimants often contradict their own basis of claim. It's preventable. So for example, your basis of claim form might say, oh, my father found out I am gay in 2021. And then during your oral testimony, you say, oh, my father found out I was gay in 2020. So this will require a reasonable explanation because if the member holds your testimony and then makes an adverse credibility finding and you are not able to explain that inconsistency and that contradiction, it will have an adverse effect on your case and it could lead to refusal. So it could be translation error while you're writing the basis of claim form if you use the aid of an interpreter, or it could be memory confusion due to trauma because you are not in a composed state of mind as at the time you're putting down the narration. It's also important to make the correction before you go into the hearing because your claim can be amended at any stage before the hearing. At least you submit your documents 10 days before the hearing because the Refugee Protection Division rules contemplate amendments in situations where there are errors that you notice as at the time you submitted your basis of claim. Then interpretation issues. So when there are problems, you have to signal those problems by saying, interpreter, please, this is not what I said. Interpreter, please, you omitted what I said here. It was not a house, it was a hotel. It was not a hotel, it was a house. You have to correct those translation errors when you observe them, because it is what the interpreter says in English that the refugee board member takes into account. The member might be understanding your language, but the member will not listen to what you're saying in your language, but what the interpreter says in English. That's what the member is listening to. So if at the point of interpretation, you don't, the interpreter does not properly interpret what you said, at that point, you just signal that there's an interpretation issue and the member will take note of it. So do not let those errors accumulate. And then do not let your emotion to overwhelm you. Sometimes some claimants can shut down during the hearing. They can't speak anymore. Sometimes you can cry uncontrollably and the member might ask for a break. Sometimes you can become confused. So it's important to always ask for a break. If you have become emotional at the point that you can't speak, you're confused, your brain is clouded, you can't think clearly, you ask the member for a break and they will gladly oblige you a break. There could also be situation of cultural misunderstanding. The members may not understand why victims are silent when they ask them certain questions, or why your persecution is hidden, or maybe why police is not trusted based on your country, or why your family is trying to enforce some cultural norms. It can be a situation of LGBT where your sexual orientation is concealed. So there might be a cultural misunderstanding by the member. So you have to explain the cultural context clearly based on the situation in your home country. And then it's very important for you not to overtalk during your hearing. So giving long and unfocused answers, it could create contradictions. Your answer structure should be short, direct, clear, and then explain if needed. Late evidence is something you need to avoid. A member might say, I'm giving this document little probative value because it was submitted late without explanation. So you have to explain any document you submit late. You must present an explanation and file an application for late disclosure of documents if you're going to submit documents when the deadline for submission has elapsed. Then the chairperson's guidelines. So the chairperson's guideline for talks about gender claims, and it recognizes shame, situations like power imbalance, delayed disclosure, trauma impact, and cultural pressure. So members must use a trauma-informed questioning when asking you questions if your claim triggers chairperson's guideline 4 and it's a gender-based claim. The members must also use sensitivity to approach those issues and non-confrontational tone when asking you questions based on your gender-based claim. And then if your claim is based on sexual orientation and gender identity, your SOGI claim sometimes recognizes fear of disclosure of sexual orientation, internalized homophobia based on your home country, secrecy, cultural danger, and maybe difficulty producing documents and psychological barriers. So members must avoid stereotype-based credibility assessment. Members must also consider why a claimant did not disclose earlier and respect cultural realities, and then understand that your sexual orientation can be fluid, the fluidity of identity. Members always understand that. So I will take a break at this point to know if there are questions, and then we can we may go on a break. Do we have questions at this point? I've said a lot.
Yeah, thank you so much, Barrister. Please, if you have questions, raise your hand or you type it in the chat section. We have 10 minutes break. So let me know if any of us have questions, please. Raise your hand through your tool session. Thank you, Chairperson. Excellent, concise, and delivered. I know English. Be bad asking for an interpreter. Okay, someone, one Patrick Mogalo said, asked in the chat section, he said, I know English. Would it be bad asking for an interpreter even when I know English? Yeah, of course. I'm sorry. I'm not seeing your question.
It's okay. It's okay.
Okay.
Yes, you can always ask for an interpreter, even if you know English, because there are some questions that they can ask you in English that you might be confused at that point, and you might need an interpreter to break it down for you in your local dialect for you to really understand the question. Because most times, overconfidence can lead you to give a wrong answer to a very straightforward question. And then you can also ask for an interpreter because you might not understand the accent of the member. So it's also important to consider the accents of the member and then ask for an interpreter. If you're flowing well with the member, the interpreter can be on standby. And then whenever there is a problem, the interpreter can jump in. So it's always good to ask for an interpreter if you need one. Someone asks, are the chairperson's guidelines binding? Yes, the chairperson's guidelines are binding because the guidelines are made by the chairperson of the Immigration and Refugee Board. So it's meant to guide the course of the proceedings. So it's binding.
Any other question? Okay, Tammy raised his hand. Okay, you can ask your question or unmute and ask your question, please.
Hello, thank you very much.
You're welcome.
Thank you for this very insightful session. I have a question, and it still goes back to the chairperson's guidelines because I read somewhere that they're supposed to use it, but maybe in cases like when you want to appeal to the RPD, if you allege that a member has not followed the guidelines, I've seen some case law where they say, it's not law, it's a guideline. So I don't know how to approach that because I have like something similar right now, like on my desk.
Yeah, so guidelines are meant to be followed by RPD board members. So if a member does not follow a guideline and it leads to miscarriage of justice, that's a good ground of appeal. It's good that the member didn't follow it, and it's good to help your clients win the case because you're going to make a point out of it that the failure to follow that guideline led to injustice and it led the member to make an adverse credibility finding because, for example, the member relied on stereotype or the member did not consider the trauma and the psychological condition of the claimants. It's a good ground of appeal. And on the appeal division, they can overturn the case if you make a good argument and if you make a good point based on the member's failure to follow the guidelines.
Thank you very much.
You're welcome. So I have another question on the chat. It says, please, what's usually the time frame for submission of evidence once date's given? Okay, once the date is given.
So it's important to work with your counsel, whoever is representing you at the proceedings. The IRB requires at least 10 days before the date for hearing for all your documents to have been submitted. Your counsel might require earlier than that because your counsel will need time to review the evidence and also to compile the evidence and to submit the evidence. So it depends on how your counsel is trying to work on your matter.